the Constitution is talking about the minorities, both linguistic and religious, right? Which means the government gets to make laws protecting properties or endowments or anything as as far as they stay to the secular activities, they get to do that. As abhi ke liye to, those are the judgments they say that the secular activities state can meddle with, right? Let's go with that. So accordingly, the government gets to make these laws for better regulation in terms of the secular activities of these endowments and properties. Now, coming back to the point that I made, it depends on the intention of the legislature. What would be the ask for community versus community? Let's not say versus, community wise, and what powers they would give, what constitution of the body would be, what recourse a man would have if the person is aggrieved by such body's decisions. All of this is actually completely coming out as, I would say, appeasement for one community, and the other community is no to understand. I would say, think from the point of view that a central government, be it any party, actually thought of passing an act, central act, to protect or let's say promote property grabbing by one community, whereas there is no central act for any other, for let's say any other minority for that matter, apart from Sikh. There is no other minority community which are far less than this particular community. They have no population to them. They would hardly have any properties which would really need protection. Their religious endowments and properties would need protection and regulation, basically. So they are not being protected. Why is this just one particular community, like star of the eye? Why is it so? And why is it that the majority community is being let go by the central government? Let's say not have a central act. I'm not saying give a central act. Even there is a different view in the Muslim community. So I don't exactly know, 2019 or around that time in Madras High Court, the Madurai bench was hearing a matter where Muslim community, a particular body from the Muslim community had challenged the Waqf Act, saying, why is the government meddling in our affairs? We don't need a Waqf Act. So it's not as if they wanted, everybody in their side also wants it, just like we say we don't want them meddling in our temple administration. But it's not, the legislature is not treating it, every community and every minority at par. This is not a particular example for you to see. You can also look at other schemes, other educational schemes, and everything else that goes to a particular community, and compare it with the other communities, and let's forget about the linguistic communities because they're nowhere in the picture. So you're like looking at, appeasement. It's just clear appeasement. There is nothing else there. This act itself is, the intent is appeasement. And hence no other party or any other government for that matter would want to put it down or stretch it out.
Right, but then we always have the courts. We always have the Supreme Court
You
to
always
challenge.
have the Supreme Court, yes, which believes this is no more religious anymore. This is not a religious matter. You're not being discriminated on religious grounds by a body that is religious.
So, I mean, what we have at hand is a situation where we can simply make the the best use of the tools that we have with us.
So what I guess is the solution is, since there is no state act, it's the central act which is being, applied to states. And as far as I know, there are around 5 or 6 states that don't have Waqf Act, applied to them. One of them is Arunachal Pradesh. I guess I don't know about the population of that particular community there, but there are states who have not, notified the Waqf Act for their state. The governments have not notified them for the state. So let's look at the Central Act. Let's evaluate that. Look at the unconstitutional provisions, and if the intent itself is unconstitutional, so we need to look at the proper provisions and the proper challenges, and not go in the net bit and try that everything be treated as trust or comes under one umbrella. I don't know how that will help, putting everything into one umbrella, even religious endowments and everything. There is that plea also where they want this one trust act which deals with everything. So I don't know. I have not examined that, uh, suggestion, but I would say at least for this particular act, there are better ways to analyze it and pinpoint the unconstitutional parts in it. So I'm figuring, the best so far would be if you challenge the tribunal itself, if you challenge the tribunal and the legislative, power to make it, since there was none. If the tribunal goes out of picture, you would at least be open to challenge board's decision in the civil court. Let's say that would be a good start.
Yeah. Absolutely, absolutely, Shaktiki ji. That I mean, it's very, very important for a layperson to be able to challenge or to be able to be heard in a court which is neutral, which is religiously neutral, which is
Not just neutral, but decides matter for it. It it has to be available, as in a civil court is something a common man can approve. If you expect him to go directly to the Supreme Court after the tribunal, I doubt everybody would be able to do that.
Please remember to subscribe to us and switch on the notifications for this channel. For our other social media links, more content, and to support our work, please visit citti.net. Dhanyavad. Namaskar.